Let me introduce myself first. My name is Alan Goldberg. I'm a partner at Stradley, Ronon, Stevens & Young in Chicago, and I am pleased and privileged to be joined by some very distinguished panelists who I will introduce, starting from my left. We have Chris Stanley, who is a general counsel from Loring Wood. To his left is Nancy Morris, who is the Chief Compliance Officer of Wellington Management Company. And to her left is George Dravasovic, who is the Global Chief Compliance Officer of Artisan Partners Limited Partnership. Today, this panel and myself, we're going to be discussing with you vendor due diligence and vendor contracts. We're going to try and divide the panel into two parts. One is going to first discuss the vendor due diligence process, and then we'll talk about vendor contracts and what you folks should be doing in that regard. So I'm going to kick it off, and as the outside counsel on the panel, I thought it'd be good to, and I always, when I speak on these panels, like to try and set the legal base, because I think the value add in this panel is going to be what the in-house folks are going to say, so you can compare and contrast your practices to those. But I think before we even get there, we need to start with what the legal base is, and so I think I'm going to very briefly try and set that. Obviously, there's going to be a little bit of an overlap from some of the previous panels, but I'll try and not to have a great deal of overlap. But, what is the law? What do you need to worry about with vendor due diligence and vendor contracts? And so when we started preparing for this panel and I started thinking about it, first thing I always do when I talk to clients is, all right, what's the law? And I took out the Advisors Act, and, there wasn't really much in the Advisors Act under vendor due diligence. So I said, aha, I'll go check the rules. There's no rules under the Advisors Act for vendor due diligence. So I did what any good lawyer does, and I checked other precedents and other manners in which people can take a look at what the law is on vendor due diligence. So I checked enforcement proceedings, a little bit of nibbling around the edges about commentary and some enforcement proceedings. Checked out the no action letters. There really were no action letters, so I'm like, well, I'm a lawyer, I got to talk about the law for vendor due diligence, so what am I going to talk about with the panel? And what am I going to talk about with the audience? And so what is out there are pronouncements. And what does that mean? So in the past several years, you had pronouncements by the SEC staff stating how important the vendor due diligence process is to registrants, registered advisors. And thereafter, this past June, the SEC proposed the business continuity and transition plan rule. And within that proposing release was the clearest statement of the Commission's views on how investment advisors should consider and assess vendor due diligence and vendor contracts. So now why am I making a point about emphasizing, well, this is a real pronouncement? Well, on the one hand, it's a Commission pronouncement. It's in a proposing relief. It's the voice of the Commission. On the other hand, the rule hasn't been adopted. So what does that mean for you folks here? What and why am I emphasizing it? As a pronouncement, it is a potential to be used by the Commission or its staff in circumstances in 2020 hindsight where they can go and examine you folks in an enforcement context, in an examination context, and they can say, there was this pronouncement by us, and your policies and procedures were not equivalent to or did not meet the metrics that we set forth in this pronouncement of us. And they could bring a 2020 hindsight 38A1 case under 1940 Act or 20647 under the Advisors Act. I've seen, and I was a former enforcement attorney, so I've tried to do this myself. You can bring a case where you had a failure to supervise, where you had an aiding and abetting violation with the vendor. You can bring other types of cases all in 2020 hindsight. So while the point here is that there's no specific law, which was I started out with, you have to be cognizant of what the Commission said. And now I'll talk very briefly about, here's what the Commission said, and to set the table for what you need to know about so that we can go, as I said previously, to hear about what other folks are doing. And because a pronouncement in a 2020 hindsight is a facts and circumstances type of case that they could bring against you, it would be great for you to be able to benchmark yourself against the panelists here. And more importantly, if you have questions, if you want to have comments, if you want to say, here's what we do, here's how we think it is better, let's do that. Let's have a conversation. Let's try and compare and contrast so that everybody's in a better circumstance in that case where we do have a 2020 hindsight case. So what did the Commission say in the June 2016 adopting release for business continuity? And again, I apologize if there's overlap, but I think it's important to emphasize what actually occurred and what the Commission said. I mean, the Commission started with the premise that Section 206.4 of the Advisors Act allows the commission to adopt rules to prevent fraud. Okay, very broad. Then they go down that very broad statement and they say, well, an advisor has a fiduciary duty. Okay, yes. And as part of that fiduciary duty is to protect clients' interests from being placed at risk if the advisor, RIA, can't provide those advisory services. And it then went even further to say, we believe it's fraudulent and deceptive for an advisor to hold itself out as providing advisory services unless it has taken steps to prevent those clients' interests. And it has gone from that very broad statement of fraud to deception to protecting client interests to saying the following. A registrant, and it's in the context of a business continuity, but I think we can still learn in the broader sense of the Commission's view on vendor due diligence, a registrant's business continuity and transition plan would need to include processes to identify and assess third-party services critical to the operations of the advisor. That's the Commission's pronouncement. That's what we all have to work on today, and that's what we have to learn about. And then the Commission said, okay, so with that broad statement, we're going to provide, thankfully, and helpfully, actually, some guidance as to what that means. And the first aspect of that is identifying the critical functions and services provided by the advisor through third-party vendors. And the part of that is very important there is, what is the Commission deemed to be something that is critical? And they gave a series of factors as to how registrants should examine what are critical functions that are provided by third-party service providers. And the list, it's in the materials, but I'll go over it real quickly. The day-to-day operational reliance on the service provider, whether you have multiple providers, whether or not the service provided by the third party includes direct contact with client or investors, whether the service provider is maintaining critical records or able to access personally identifiable information. Those functions provided by a third-party service provider are deemed by the Commission to be critical. And then the Commission even went further by announcing, here's the functions that we think are critical per se. So automatically these functions, the Commission has deemed, and to make sure that's clear, the functions that are provided by a third party are deemed to be critical. And I think none of them will be a surprise as I go through the litany and the laundry list here. But again, if you have a third party outsourcing with portfolio management, that's critical. The custody of client assets, the Commission has deemed critical, which I'll digress a minute, and then I read through it, and I scratched my head a little bit and saying, well, hold on, in a normal registered investment advisor context, that's not, the custodian is not the entity with whom the advisor contracts with, that's with whom the client contracts with. But nevertheless, that's in the laundry list. Trade execution and related processing, pricing, which I think is very important and makes sense, client servicing and record keeping, and financial and regulatory reporting. So those are the functions that the Commission deems to be critical. And then it gives you, the reader, some important steps that you need to take into account, including go review your contract. And I think that's pretty obvious, and we'll get into that a little bit later in the presentation. And then the Commission also goes on and says, here's what you should do. And here's where I think it's going to be a nice segue between what the lawyer's talking about and what the in-house folks are going to talk about. What do you need to do? And then I think it's key here is that the advisor, again, in the context of business continuity, should review and assess how the service providers plan to maintain business continuity when faced with significant business disruption. We could take that statement and take out business continuity and include any of the functions that the advisor is going to, in its day-to-day existence, deals with, and put that statement in there. You should review and assess how those service providers plan to maintain their services in times of stress. And then the Commission, the last thing I'll talk about before turning over to my panelists, and the last thing that the Commission said is it provided some examples, and this is again where I think we're going to have a nice segue into what the panelists, my fellow panelists are going to talk about. Here's what we found in terms of our examinations, in terms of our observations, as to what some registrants are doing, again in the context of BCP, but I think you can use this in any type of vendor due diligence. The first is reviewing a summary of a service provider's business continuity program. But again, reviewing a summary of the service provider's interaction with the registrant. Requiring the use of a due diligence questionnaire. That seems to me to be due diligence on a vendor 101. Requiring the use of assurance reports and controls by an independent party. SOC 1s, SSAE 16s. How do you assess the internal controls of your vendor with whom you have a contract? Requesting certifications or other information regarding that provider's operational resiliency and implementation of compliance policies, procedures, and controls relating to its systems. Again, getting a certification from your vendor on their internal controls. Reviewing the results of any testing and conducting on-site visits. And I think the last one is one of the most important things that we'll talk about on this panel, and that is how do you go about to do an on-site due diligence when a vendor may have requests from multiple people to come on site at the same time, and how do you conduct that in a courteous way but in an effective way, which is one of the things that we'll talk about as we go forward. So, as I said, I have tried to set the legal base as to what we need to do, what the SEC has asked. And so now, it's going to be my privilege to turn it over to the panelists, and I'm going to ask questions to the panelists as to what they do in their shops and get their reaction. Again, if you folks have questions or you want to if you want to interrupt and say, hey, that sounds great, but please do so. Let's make this as interactive as possible. So, question one to the panelists. Here we go. How is due diligence structured at your firm? I mean, a very broad question, but I think we can learn from that broad question. So, Nancy or George, who's going first?
So I'll go first, and I can talk in detail or broadly, but we actually do not outsource due diligence. We actually structure it in-house. We have a vendor management group. It's not 55 people. I think it's roughly about 2 or 3 people who are really there to help coordinate a much broader response across the firm involving subject matter experts and others. I think the one thing we do, and that is out there are some third-party external service providers that focus on IT-related controls of your vendors. We've engaged their services, and that gives us some real-time insight into events that are occurring at those firms with respect to their IT infrastructure. We're also on that, so our clients see us as well. But it is a good resource, particularly with respect to real-time IT information.
And at Artisan, we also do our vendor oversight in-house and our vendor diligence in-house. We have a slightly different approach in that we do not have any business unit dedicated to vendor oversight. What we have are a series of internal, call them relationship owners or relationship managers, who have the day-to-day interactions with the vendors. We've created, over the last few years, a more formalized process where we've done a cross-functional committee internally that has established some of the more, call it consistent, formalized approaches to vendor oversight and diligence that you might find in a business unit, but more in the form of a committee. And we push that out to the individual relationship owners and relationship managers. It helps to fill in some of the blind spots that they might have in their ordinary day-to-day management of the vendor. So if you're an accountant who's overseeing an accounting agent or a fund admin, it helps you make sure you're addressing things like cybersecurity, business continuity, et cetera. And then we have a team of subject matter experts who control various parts of that process. That could be done in the form of a supplemental questionnaire. For example, if someone is maintaining key data for you, then we have a special questionnaire that goes out to that vendor, and we have a subject matter expert who kind of controls the back and forth with that relationship. And similar to Nancy's process, we have occasionally we use an outside consultant to give guidance on an RFP process if it's IT specific. I think that's an area where we do supplement as well.
So let me ask you both a question. So if you had to look back in the past several years, given the pronouncements that I talked about in the past, how has the resource devotion been, in your firms? Has it increased? Has it remained the same? What is the intensity level? Has it gone up or down?
In our world, it's gone up. We've gotten more formal over the last few years, and I think there are advantages to them. I think one of the first ones I'd point out is one I've already highlighted, which is if you have a day-to-day relationship manager, they may not be thinking of the full range of issues that could arise with respect to a vendor, so formalization helps to kind of cure those blind spots. It also ensures greater consistency across relationship managers within the firm, and formalization can also make it easier to walk an outsider through your vendor oversight process. Those outsiders can include regulators on exam. They could also include clients as part of the operational due diligence process.
Yeah, and I think I would say we've definitely gotten more formal and taken a number of steps to formalize the program. We've always had sort of subject matter experts involved across the firm, but we've done a lot more similarly to help define sort of the standards that we expect of our vendors, depending on who those vendors are, to make sure the business owner, and there is a business owner for these vendors, I don't own it, and the vendor contract group doesn't own it, it's really the business who owns it, making sure that they appreciate and understand issues, that if they actually become aware of them, they do get escalated to a broader group that looks across all vendors with respect to issues that can arise. So I would say starting to see much more increased formality around a vendor risk management program, much more formal documentation around that program.
So then let me ask you a follow-up question. So it sounds as if the intensity is increased and the formalization is increased. What has been your response to your business people? Because this is obviously a cost center, not a profit center. So what has been your response, and how have you explained to your business people and saying why this is necessary? Why is the formalization? Why is the increase in resources necessary?
I think the regulatory guidance has helped in that regard. I think I think people have alluded to the BNY incident from a little while ago, where a lot of people had trouble kind of calculating their NAVs as a result of issues that a service provider was experiencing. That, I think, more than anything, lit a fire under people, and it became kind of obvious that, yes, we have to address this more broadly, maybe more formally.
I also think just the evolution of risk management programs generally at the advisor level. I mean, 10 years ago, risk management was probably not something that'd even be on a panel discussion. It's now, every day you're hearing about risk management, the evolution of risk management in the industry. Vendor risk management is a component of that, and I think you're right. Some of the SEC recent pronouncements, be they the enforcement case, really opened people's eyes regarding the need to have a program in place and to understand who their vendors are.
And I'd say if you are in the earlier stages of your formalization, the compliance team or the CCO has a pretty key role to play in that. They're almost like they assemble and marshal the subject matter experts. They help articulate what are the good components for an vendor oversight program. Don't forget about cybersecurity. Don't forget about business continuity. And they are a good, I guess, spokesperson for consistency across teams within the organization.
And if you're a busy CCO, I will say that's why it's really nice to have a vendor management group who actually does that coordination for you. And I'm actively involved. Folks on my team are actively involved in that. It's a lot of work.
Yeah.
It's a lot of work.
I think I'm preaching to the choir here, but I think at least historically at our firm, compliance had been the de facto dumping ground for vendor oversight and management, and we are evolving away from that. And obviously compliance plays a critical role, but it can't play the sole one-dimensional role. There's a lot of other folks in the company that have a lot of valuable input that they can bring to a vendor relationship and how we oversee them. It's been an uphill battle, frankly, to sort of break the mold and move not to a compliance-centric approach, but a broader approach. But we're making progress, slowly but surely.
So now that we set the table, I suppose, with your programs, let's drill down a little bit. I mean, the first question in the materials, and I do think it's a worthwhile question, and it segues into a question we've already received from the audience, and that is, how do you define who a vendor is, and how do you define whether that vendor, as I stated previously in my introduction, provides critical services for you? What is the test that you folks use to be able to identify this is really key? And I'll make a two-part question to the panel, and that is, and it's been a question from the audience, and that is, would that include utility vendors? Would that include internet vendors? How do you make sure that in the job that you do that you're separating the wheat from the chaff?
I think that's just the fundamental question. First of all, is the first thing we did was do you know who your vendors are? And I think firms would probably be absolutely shocked to find out how many third-party vendors service their organization in one way or another. But I don't even think you can get to sort of identifying who your critical risk vendors are until you know who your risk vendors are, what services do they provide to you, and that includes internet service providers, that includes custody services, that includes broker-dealer counterparties, just everybody with whom you may have a contract that provides some sort of service to the firm. You have to categorize that, and that is no small task. I think one of the key things that evolved for us over the course of the past couple of years is that we actually undertook that exercise, and we have a database now that shows us every single vendor with whom we have a contract. That includes legal vendors, people who provide us legal services, anybody who's providing the firm a service. We have categorized that. And in that database, we have certain elements that have to be filled out regarding each and every one of those vendors. And those elements help us determine whether or not a vendor is considered a critical high-risk vendor. And that would include making sure we understand who has access to confidential client and firm information, who has access to the crown jewels, who has access to our trading, who has access to portfolio holdings, who has access to confidential client information. It's trying to identify, sort of the critical things from a regulatory point of view that can really get you into trouble if those things somehow get revealed. And then also identifying vendors whose services are so critical to you that you can't function if they're not up and running. And that, in the case of a mutual fund, for example, that does include pricing vendors. In our case, pricing is important, but it's not quite as important because we don't really have to worry too much about daily valuing funds, but we do have to worry about vendors who we've hired to do that for us. I think, so those are all the kinds of considerations that come into play: the ability to affect securities transactions, the ability to send data, the ability to interact with your custodial banks. All of those venues provide very critical services for the firm, and the first thing you certainly want to know is who your vendors are, as I said, and only then can you tell which ones are really providing these critical services and which ones have access to critical client firm information that you don't want to be displayed across the internet.
And I totally agree with what Nancy's saying. And I think that when you think about compliance's role in that process, where compliance can add some value is, and again, you think of legal in contrast to compliance. Compliance is, embedded with a lot of the business processes. It's helping give an understanding of prioritization vis-a-vis the vendors and the service providers, identifying, as Nancy said, the ones that are critical for your day-to-day workflows, so that if they go offline for whatever reason, you have a gap in your workflow and you can't cut a daily nav, or you can't settle trades, you can't perform mission-critical functions for the organization. So once you've identified those service providers, you call them out, you tier them, and then you customize your oversight process based on the nature of that relationship. So yeah, we've engaged in some tiering within our organization, and then the different templates that we have at the committee level that apply to vendors are based on their tier status within the organization.
So let me, I'm sorry, go ahead.
I was just going to mention one simple lens that we look through is what vendors, if something were to happen with that vendor, would have the most negative impact to our clients. At the end of the day, we are fiduciaries to our clients. That's who we're in business for. And so, to just break it down to the simplest level, what vendors would have the most negative impact to our clients if something were to happen to them, either in a business continuity, cybersecurity scenario, privacy breach scenario, or just a failure to provide the services that we've contracted with them for. But at the end of the day, it's the clients who we're in business for.
So let me ask all three of you a question, and I've received two questions from the audience, so I'll ask it all at once. Come on, guys. What about if you're dealing with a huge vendor that's a Fortune 500 company that's got a huge staff? And I say this a little tongue-in-cheek, knowing about the Bank of New York case, because I had several clients that I had to deal with that, and it was a very long summer last August, 2 August ago, where every day we were on calls until 11 o'clock at night trying to figure it out. So I know Bank of New York's a huge firm, but how do you deal with the fact that you're dealing with a very large, reputable firm? Is there any different level of attention that you would apply to the larger firms?
There are a range of vendor types, and yes, you kind of have to calibrate your diligence and oversight based on the vendor's role and based on who they are. So for a larger organization like that, yes, it's going to be difficult for you to get them to change their practices, but it is important for you to understand how they're structured, how they work, what their key dependencies are, and it's important for you to think about your plan B when they go offline. So you have to think, okay, well, what are we going to do if they go offline? how good, once you've conducted your initial diligence and you have an ongoing relationship, it's important to monitor the key performance indicators to make sure they're doing a good job. At what point do you put them up for RFP if they're not doing a good job? What have been the incidents that have arisen in that relationship, and how has the organization responded? And if that response is not adequate, how do you get better results out of them? And that's where understanding the structure kind of can help.
Yeah, I would say that's exactly, how we approach. We're not going to we're a big organization, and there are certainly vendors that we can, if you will, pull our weight on. But even being big, you're not going to get people necessarily to change a lot of their internal practices. What you really do need to do is understand a bit about what they are, what's the risk that pose to your organization, and is that an acceptable business risk based on your business and your facts and circumstances. I think you can always prod people, you can always urge people, and if it's a critical vendor, you may just have to say, unless this happens, we actually cannot utilize your services. We want to utilize your services, but I don't think I've ever been involved in a vendor due diligence oversight or ongoing due diligence where we've had to completely just back away and say, you're just not up to snuff. And it may be because in the initial venue clearing, if you will, we're excluding those kinds of vendors to begin with, in terms of who makes it even into an RFP process. If the business doesn't know who they want and you're considering multiple vendors, it can play a bigger role there because you might have a little bit more sway and you might be able to go with a vendor that's going to give you more information than not.
Okay.
The other thing, actually, I did want to mention is one of the things that I think is interesting when you do sort of a categorization of your vendors. There's a lot of information that flows from that, including maintaining a database where you can maintain incidents that occurred during the course of the year so you can look back at your vendor and kind of try to appreciate, have you had a lot of issues? Have you not? Have they been responsive when you have issues? Those all are sort of very helpful as you get to the annual due diligence process, and very helpful for the business. The business doesn't want things to go wrong either, particularly if you're talking about a critical vendor. They very much appreciate the need to have this vendor up and working properly and to have the kind of controls that we think are important, that our clients expect us to have. Sort of keeping up a database and keeping up incidents throughout the year and how they were resolved is very helpful. The other thing we did, and I just think this is awesome. I was just telling these guys that our new vendor management people, we don't have a whole lot. We have like 2. They love this stuff. I can't believe they love it. They are so excited about the job they're doing. So look for someone like that because, this is not exactly the most exciting topic, and they've actually got me extremely interested in what they're doing and how they're doing it, in part because of their enthusiasm about the work that they do. One of the interesting things they did, for example, and some of you may have done this, is they've actually mapped out across the globe where all our critical service providers are. And we can all of a sudden see where we've got geographic concentrations or high-risk country concentrations for a vendor. I'm not sure exactly what we're going to do with that at the moment, but starting to understand where, in addition to this, the plain risk with a vendor, you're going to have other exposures from a BCP perspective, for example. Like if you have a ton of vendors that are located in a particular geographic area and that gets hit by a hurricane or an earthquake or something, you may have a very high risk that your vendors are going to go down.
And some vendors will actually accommodate your need for geographic diversification.
Diversity,
right?
Yeah.
Especially on the cloud storage side.
Yes.
Amazon and others will help work with you if you need to reposition your data or your assets.
Well, I think I figured out, Nancy, why they're so enthusiastic. If you're across the globe, I think I need to do an on-site due diligence to the south of France. I mean,
Take a couple of
the
weeks.
budget hasn't allowed for that yet.
You got to get some vendors in Hawaii. So let me switch gears about now that we've identified the importance of the risk program, and we've identified who the important service providers are. Let's really dive deeper into how do you go about going and kicking the tires on an entity. So we're going to switch the slide down here, and I want to talk about the actual process. So we've got the team, we've identified the vendors. When somebody new comes in the door, potentially somebody new comes in the door, well I think Nancy's probably right. It's unlikely that you're not going to get in the door unless you've done some initial business vetting. How do you folks go about with a new vendor? What is the process, and how do you make sure that you're examining that entity correctly?
I think in our organization, think of the relationship manager as the person who will own the day-to-day relationship with that vendor going forward, and the relationship owner would be the person who that reports to, right? They tend to take the lead in that process. They're the ones who best understand our organization's needs vis-a-vis that vendor. So they will run point in the RFP process. The committee's function is to assemble the team of subject matter experts who help run individual components of the diligence and oversight process. And depending on the vendor, that could take various forms. For the more significant vendors, that tends to involve questionnaires, phone calls, and on-site visits. But the key with the subject matter experts is to get them to know from the relationship managers and the relationship owners, what is this vendor doing for us? What is their role in the overall process?
So I would say we have a similar approach. Again, I'm fortunate, I do like the idea of having a couple folks in vendor management who coordinate the whole thing. They're really the project managers, they're the keeper of all the data, et cetera. But the first thing you do, and I recently had an RFP go out, is you sit down with the vendor management group and you go exactly through what your business needs are, what you're looking for, et cetera. And then they will help you put together the RFP that we want to send out to the vendor. We do RFP virtually all of our vendors. Depending on the vendor, that RFP may be very, very long, or it may be, a little bit shorter, but we have essentially a built-in database of questions that we've all agreed need to be responded to by a vendor. And then in addition, because I'm the business owner, and just like any other business owner, are there other things I want in that RFP that I think are important, particularly with respect to the services that are going to be provided? And so our process is basically to RFP a new vendor. They do have to respond to our RFP, and that's when we get our subject matter experts together. I wouldn't call it a formal committee, but it's a working group. There are designated individuals from all of the various areas that are covered by the RFP, which would include, cybersecurity, business continuity, any technical expertise that we need on something, et cetera. All of those people get together and have to review the responses, and in particular are charged with review and sign off of the responses relevant to their field of expertise. So our cybersecurity folks, if this is going to involve some sort of highly technical IT related issues, they have to get comfortable with the controls and they have to sign off on it, just as I would sign off on any of the compliance related controls, for example, that are asked for in the RFP.
And if you are at a smaller shop that doesn't have maybe the dedicated vendor oversight business resources, don't despair. It can actually be a little bit easier at a smaller shop to coordinate those internal resources because you're dealing with the usual suspects in terms of the subject matter experts, et cetera. And once you have, and for us, formalization really helped with that. Once you have templates drafted where there are placeholders for different subject matter experts to address particular topics, it's much easier for the relationship manager or owner to step in and just make sure that the usual suspects are doing their jobs.
By the way, there is, especially for smaller firms, but we actually, our folks belong to this, I don't know the name of it, but it's an organization that focuses on, it's like a trade association that focuses on due diligence. And it is especially helpful in the IT space for folks. One of the things they're working on is really a standardized due diligence questionnaire, for example, for IT-related areas. There's an asset management group within this group. I can't recall the name of it, but shoot me an email, and I'm happy to get the name to you. It's a good resource, particularly if you're a smaller firm, to be able to join in and have the benefit of their the larger group as a whole and what they're focusing on for due diligence.
So several questions from that good introduction. I mean, one question is, at what point, if at all, would you bring in outside counsel as part of this process?
Probably not very often, to be honest. When we get to the contract negotiation is probably when we would bring in inside counsel in to the extent we need to, because we do also have some procurement specialists who specialize in understanding how to negotiate these contracts. You do raise a good issue, though. I mean, I think if we ever came up with a vendor that we thought was absolutely critical but which we had some significant concerns about that we thought could pose some issues. We might seek some advice of outside counsel. One of the other things we also review is we will look to see, are there any lawsuits against these vendors? Have they been subject to SEC or other, foreign regulatory authority cases, suits, et cetera? Maybe we would go to outside counsel to get a sense from them about, geez, this, have some concerns here, but we need to use the vendor. Although by and large, I think, to be honest, given our size, we're able to handle a lot of that analysis in-house.
I would agree. The other area it could come up in terms of the ongoing oversight, if you have a significant breakdown in services that have regulatory implications for you, you might call in outside counsel to help you navigate that process. What is the best option among a series of not very attractive options? So incident management is key. And on the background checks, it's a very good point, and there are some services, some negative news services out there that you can retain for not a lot of money that will give you an initial high-level background check on the vendor and will give you ongoing reviews when things go wrong with them.
I'm guessing you got a lot of calls, for example, when people couldn't strike an NAV. That strikes me as I'd be on the phone right away saying, what are we going to do?
Well, yeah, I mean, we're talking about, agreed.
It's the crisis management.
Indeed, no question. But again, I think it was a purposeful question at what point in the due diligence process do you involve outside counsel? You both gave me the answer I expected to receive, but I think it also bears sharing with the audience that my firm and I represent large and smaller shops, and I do think that outside counsel, not that we're going to go kick the tires for you, although we certainly would be happy to if you want us, but we've seen a lot of RFPs. So my firm will have samples that will be able to help out smaller firms that don't have the resources that your two firms do. So while I, again, fully expected the answer that I received from the two panelists over there, their outside counsel can be used as a resource. And there'll be additional public service messages from outside counsel later on. One other question is with respect to the onboarding that we received from the audience that I think is a very good question. Is there any specific additional work that you do for counterparties and trading firms? I mean, that seems to me to be, as I announced previously, a critical function that you folks have to deal with. Is there anything in addition that you do for the investment side, trading or counterparties, as part of your processes?
Well, there I think everyone probably is still dealing with, thinking through what immediately came to mind when I heard the question was Lehman Brothers and people's exposure to Lehman Brothers when it went under. We tend to handle those counterparty and trading relationships under the auspices of our Best Acts or Trading Oversight Committee, and there's a group there that focuses in on those relationships. And I'd say there's some highly specialized info that you probably want to get in terms of where they're directing your trades, different venues, et cetera, that would fall under the Best Acts category. But in addition, we track things like creditworthiness in light of Lehman.
Yeah, I would say we do the same thing. I can't recall way back when we may have set up contracts, but by and large, we have trading subject matter experts who look at all aspects of the relationship. They report through to a committee. They would be constantly looking at regulatory developments. They would constantly be looking at the financial condition of the counterparties and the traders with whom we do business. The kind of business we're doing, is it DVP or is it principal trades? Is it derivatives? Is it swaps? Is there margin being held at a broker-dealer? All of those things would factor into the focus, and I think, the layman issue was a perfect one. I wasn't there, but we had identified potential issues, and you right away have to start thinking about, are you going to trade, are you not going to trade, what are you going to do with your outstanding trades? But again, it's different in that we definitely have a focus group who understands the broker-dealers with whom we do business. We have a process for how they get approved. We have an annual reassessment for that. All of that goes on, but in many ways, it's just the same as the same as vendor management. They are the subject matter experts, and they are the group that gets tasked with this. They also own the business relationship as well.
Yeah, we're 100% sub-advised shop, so a lot of those issues aren't quite as applicable to us. But naturally, we do due diligence on our sub-advisor to make sure they're doing what they need to do with respect to trading and best acts, et cetera.
Okay, so now that we've done the initial due diligence and we've gotten the teams and we've given a description, I think we've covered it, but I just want to make sure. I mean, once you've gathered all this information, how do you assimilate all this information to arrive at a final determination that's the vendor that you're going to choose? What is the review process, which is actually our next slide? I think we've covered it mostly, but I want to make sure that there's nothing in addition that we haven't discussed already.
Yeah, I think it's, again, we get our subject matter experts together, they review all the responses, we'll get clarifications to questions if we need it. But I think, who's seeking clarifications oftentimes it's coming from a subject matter expert, they need additional color or information on a response in order to get comfortable, or there's something on, like, for example, I just had an RFP process and I wanted to understand precisely what fees were included and what fees were not, because, there's some generic language and you get like, okay, what am I actually getting for this? And can I be charged something else for something else? I wanted to understand that. I was the business owner there, so a lot of times the questions will come from the business owner as well. They want to get clarification before a final decision is made. And I know, in the end, I think we covered this too. In the end, for us, it really is the business owner that makes the decision.
Same here. A business owner is making the decision. There's typically a meeting where there's an ongoing dialogue with the subject matter experts about concerns that arise, but there's usually a final check-in with the subject matter experts. Any significant concerns, last chance, green light, and if everyone else is okay, then the business owner makes the final call.
All right, so now we have this vendor in the door, everything's going peachy. The next slide I want to talk about is ongoing due diligence. Is that different? So you have a vendor, you're comfortable with the vendor. How is that different, if at all, from your initial due diligence?
I mean, for us, there are a couple areas. One is frequency. So we risk rank all of our vendors. A high-risk vendor is going to be reviewed annually, and they will fill out an annual due diligence questionnaire, or essentially be able to ultimately go into our database and update the information they've already provided to us. The other thing that makes it a little bit different, by the way, if it's lower risk, it could be every 2 years, every 3 years, and perhaps not at all, depending on the kind of service being provided. It's just kind of knowing who the vendor is. I think the other thing that's different is that during the course of the year, and we discussed this, we will keep track of any incidents involving that particular vendor. So whatever that might be, updates on a background checks will be put into the system. If we've had like a privacy incident with a vendor, that goes into the system, including how they resolved it, what their resolution was, were we comfortable with that. So we'll have a lot more data as we go into our subsequent due diligence visits and questionnaires. But it is risk ranked. You cannot possibly visit every vendor every year, and you really do have to identify who's critical and who do you really need to keep up with on a regular basis. Apart from an annual process, by the way, also going on, which I'm sure you all have as well, is the business owner has a continuous relationship with the vendor, and on an ongoing basis, they're also charged with making sure that relationship is working and basically escalating matters if something is going amiss or awry at the vendor relationship.
Very, very similar principles applied in a slightly different way. Again, a little bit more decentralized with a committee structure. So after the vendor is identified and selected, the business owner, depending again on the risk ranking of that vendor, our templates may call for the business owner to document their plan for oversight of the vendor during the course of the year, which could involve, for the highly critical, like, the fund admins, if you're sponsoring mutual funds, could be a monthly check-in with a bunch of people. But it's a detailed plan that they do for the higher risk ones. For the lower risk ones, again, a little bit more, less frequent or less detailed.
The other thing I did want to mention, there are lots of, objective reports you can ask for, like an SSA 16 or a SOC 1 report. We routinely ask for that kind of information as part of our RFP process. The one thing that my vendor guys tell me, though, is you got to look at those reports, because we had a critical function, and it involved where the IT storage was. The SOC 1 report came back perfectly clean, but it didn't cover our particular location for our particular vendors. An auditor will go in and just randomly select the locations. Ours wasn't included. We actually went on site, did a due diligence visit, and found significant issues which we required the vendor to address immediately. So it's kind of like, you get as much information as you can, but you also have to look at it.
And if you got a more decentralized model, your business owner may turn to you and say, an SSA, what? And they may not have necessarily the context or the expertise to review a document like that. And that's where, we developed a supplemental template to help review those reports. And we have someone from our internal audit team who gives a little ad hoc training and what to look for, what looks weird, what's a qualified opinion versus an unqualified, that sort of thing.
So we did receive a question from the audience that I'd like to have addressed, and then I think we'll switch over to the actual contracts and the contract negotiation, and that is, and I think it goes to my prior point about a 20/20 hindsight case being brought by the commission. Once you have all this information, the initial due diligence, the ongoing due diligence, your template questions, what are you doing with it? Are you keeping these records as if they're required records under the Advisors Act? Are you sanitizing them at all? What are you doing so that they can't be used against you, or are you saying that they're clean documents and we're going to keep them to show the robustness of our process?
We do maintain our documentation. We have a centralized SharePoint site, so even in a decentralized process, we've got one SharePoint site that helps maintain all that documentation. We are aware that if something went wrong with the vendor, this would help establish the care with which we review that relationship, et cetera. I think one of the potential drawbacks to a more formalized process, if you've memorialized it in a vendor oversight policy that's very detailed, make sure you're doing everything that policy says you will be doing, because that becomes the standard against which you're judged for a variety of purposes.
And I think at this point, we're keeping the information as well, but you raise a great point about whether or not we ought to think about reconsidering some of that, because it's not a required record. On the other hand, it really is helpful when you're looking back over the course of the relationship with the vendor to have a full understanding of the relationship.
So now, the second part, and even though we're not giving as much attention to it as the due diligence part, it deals with the contract and the contract negotiations. And Chris is going to lead us through that. I wanted to have as the only slide with respect to contract negotiation, contact the outside counsel, but I was overruled by my fellow panelists, so I think we're going to go into a robust description, and Chris is going to walk us through the stages as to when outside counsel or internal counsel is involved, and more importantly, what are the important aspects of the contract that you should be taking a look at. So, Chris.
Sure, and this will be kind of a crash course. I know we have a balance of about 11 and a half minutes here, so I'll be going a little bit quickly, but just to start with some foundational considerations. At the very outset, it's important to understand what your bargaining position is, particularly if you are a smaller firm and you're dealing with a giant vendor. You're really not in a good position to get everything that you want in that contract. And so acknowledging that and evaluating the situation at the outset, I would say, is step number one. Step number two is consider what your risk appetite is in terms of various terms and conditions in the contract itself. Some folks are willing to have a little bit more broad-based, ambiguous terms in the contract, or maybe willing to give more deference to the vendor. Others are very tight, don't give exceptions, and really are not in the business of having any risk appetite for leeway in their contracts whatsoever. So understanding kind of what the culture and the attitude is within your firm with respect to vendor management is key as well. Also important, when it comes to negotiating and entering into vendor contracts, it's important for either internal legal counsel, external legal counsel, compliance, whoever is responsible for reviewing the contracts, to not operate in a silo. As we talked about earlier in the panel, there's a lot of important stakeholders to bring in, and you may get the reaction from a lot of folks within the company like, hey, contracts are legal's job, I don't want to look at it. Well, that's great, but that really doesn't do justice to all the things that can be either hidden or not obvious within a contract that may be important for a business line person to know. So really getting a team approach to contract development and evolution and negotiation, I think, is crucial as well. Pick your battles. This has to do with your risk appetite. Really kind of stake your flag and stake your claim on what hills you're willing to die on and which ones you're not in terms of contract negotiation. There may be some points within the contract that are simply non-negotiable. Identify those, but you also have to realize that contract negotiation is a push and a pull, and you're not going to probably get everything that you want in the contract, particularly if you are a smaller firm negotiating with a larger firm. So again, just kind of identify those hills you're willing to die on. Moving to the next slide, and we frankly already covered this. There is contract law based in state law, but there is also signals, tea leaves, pronouncements, what Alan was talking about earlier, from a regulatory perspective that we should be incorporating into our vendor contracts. So as you can see on the slide, in terms of risk rating or identifying material vendors, this is a list that Alan was referring to earlier that was in the BCP proposal. So at least as a bare minimum, I would suggest that when it comes to vendor contracts and vendor management, these are the ones you should be spending the bulk of your time on, really putting in effort and energy into negotiating these into the most favorable terms that you can possibly get. Again, understanding and acknowledging the balance of power there. So I'll skip to the next slide for the sake that we've talked about that pretty robustly. So really here, and this is based on the direction of the description of this panel here today, to walk through basically some of the basic provisions within a commercial contract, again, at a very brief level. Don't worry, I'm not going to try to bore you with jargon here, but essentially we're going to be talking about reps, warranties, covenants, rights, conditions, and indemnification. Think of the contract basically as a sandwich, or we're going to try to walk through some of the periphery items and some of the meat. So we're going to dive right into reps and warranties. Essentially, these are seemingly boilerplate terms within a vendor contract or any commercial contract that look at a point in time and backwards about what the vendor is representing to you is true. So this may have to do with their viability as a company. They're appropriately registered in their state of incorporation. They have the appropriate licenses in order to do business. Whatever the case may be, they are representing to you in the contract certain facts which you are relying on in order to enter into the contract. So in this term, reps and warranties are basically an inducement for you to enter into the contract. So it's important to understand exactly what those are and understand what the consequences are if they are not accurate. Basically, this will lead to an indemnification claim, which we'll get to in a second. But the important thing here to remember is that reps and warranties are backwards looking as opposed to a covenant, which is forward looking, which we'll get to on the next slide here. The covenants and the rights and the conditions, frankly, are the meat of the contract. This is the bargain for exchange. This is the services that the vendor will be providing in exchange, likely for compensation of some sort. It's a promise to take a certain action or, frankly, to refrain from taking a certain action, also known as a negative covenant. So here is where you're really going to dial in and see specifically what services the vendor is providing to whom. Is it to you as the advisor? Is it to your subsidiaries? Is it to your clients? Is it to certain officers and directors? I mean, whatever the case may be, identifying exactly what the firm is covenanting to provide to you and what the pricing terms are that you're going to be providing back to them is important to understand. Again, this is, and I guess one ancillary note to add on this slide as well in terms of a condition. A condition is really something that has to be in place in order for a covenant to spring to life. So for example, if you're engaging in a vendor contract with a custodian, you need to provide accurate data to your custodian, whether it's account opening documentation, investment advisory agreements with fee calculation numbers in there. That has to be accurate in order for the vendor to accurately provide the services to you. So they're not going to be basically promising to do things accurately if you can't provide them accurate data in the first place. Blowing right through to the next slide, indemnification. This is essentially one party's agreement to compensate another for some sort of a loss that's caused by the indemnifying party. And so this really is what can arise from a loss, a liability, a claim, or a cause of action. We'll get into that in a second. That has a nexus that was caused basically by one of the parties. And at its very base level, it is a way to allocate risk across the various parties, but also to identify remedies and responsibilities for when it hits the fan or when the contract really doesn't play out how it's supposed to. So indemnification really is a part that you're going to want to spend some time on to understand what the consequences are if your vendor fails to do certain things or misrepresents to you in certain reps and warranties.
So Chris, let me interrupt because we got a good question from the panel.
Sure.
Not from the panel, from the audience. And that is, and I suspect that the question was from a smaller advisory shop. How would you address if we have an adverse indemnification provision from the vendor and that is asking us, the advisor, to indemnify them? How would you deal with that?
Sure, and actually that's frankly one of the points I was going to get to on the next slide is when you read off the shelf or the first draft of contracts from vendors, Don't be surprised if they're fairly one-sided, particularly when it comes to indemnification. You could have an indemnification section where you as the client or as the advisor are basically indemnifying the vendor for everything, but the vendor is not indemnifying you for anything. And at least in my experience, what I've found is just to point that out, frankly, to the vendor and say, hey, I thought this was a partnership. We really look forward to working with you for the long term. We think that from a contractual perspective, we deserve to be on equal footing with you. Are you scared of providing indemnification? Do you have a history of losses that your lawyers no longer allow you to put this in the contract? There's no silver bullet, but starting the conversation and just pointing that out. And really the goal should be to at least get on equal footing from an indemnification perspective. But again, really, bargaining positions be as they may, that's harder sometimes than
Which is exactly what I do when I read the
Yeah.
indemnification provisions. I put the 2 pages side by side, and the first thing is to say, well, let's just be parallel. Let's see what
Yes.
the reaction is. And you go word by word, and it's very annoying that it's very painstaking, but you just make sure that everything is parallel. And you serve that contract up to the other party, and see what the reaction is. And then it comes down to bargaining power, which is Chris's initial really good point.
Yeah, you have to ask. If you don't ask, you're not going to get anywhere. The worst they can do is say no and walk away, and that maybe isn't the best vendor to do business with anyway. But again, you have to at least ask the question and try to push the envelope. And again, it's going to be a series of negotiations depending on how one-sided the contract starts out to be. But the question was very spot on that indemnification can be a hot area of negotiation in that regard. If we're not already on slide 15, we'll go there. And again, I've already sort of introduced maybe some of the things to be aware of or to understand from the vendor perspective where they're coming from. When it comes to reps and warranties, be mindful of materiality conditions. So they may only represent and warrant certain things to you that are material, not immaterial in their minds. So there may be a certain threshold standard that they automatically put in there. They may also put in knowledge qualifiers, so they may only represent and warrant to you certain things that they know of, not certain things that they didn't know of, even though they may have should known about them. So just be mindful that certain singular words can make a big difference when it comes to reps and warranties. Ignore final non-appealable judgments for the time being. That should have been on the next slide. That's my error. But also just to be mindful when it comes to just general contract terms, other limitations that vendors may try to put in. When it comes to liability, caps and baskets, this is just a fancy term to a cap to the limitation of liability. So it could very well be the case, and this is something I've fairly commonly seen, where the sole remedy for a breach of contract or a vendor failing to do something is the cost of the contract. There's no punitive damages, there's no incidental damages, there's no basically remedy outside the actual price of the contract, which really doesn't put you in the best spot if you've been experiencing a loss that exceeds the value of the contract. So one thing to keep in mind as well.
That's also going to, I assume that's also going to depend on the critical nature of the vendor, what you're willing to accept and what you're not.
Exactly. Yeah, again, this goes back to picking your battles
Right.
and the risk allocation of which vendors you're going to hammer basically to get the best terms possible, and which ones you just don't have the luxury of doing that. For the sake of time, I'll go right down to the second to last slide here, number 16. Indemnification, again, this is really where the meat and potatoes are in terms of negotiation. Be wary of clauses where vendors basically say they have no duty to defend you if you get sued by a third party, even though the vendor may have caused that third party to sue you. Also look for terminology that suggests that the vendor has the right to control the litigation in the event you do get sued by a third party. Pros and cons to that. Indemnity can also be one way, which we talked about already, where it's very one-sided. It can be imbalanced, where the indemnification paragraphs look similar, but one's slightly shorter than the other. It's important to read that very detailed. The goal should be to have it completely mutual across the board. And again, as I alluded to earlier, indemnification can arise out of losses, liabilities, claims, causes of action. These words each have a very distinct meaning, and you can think of it in terms of a sliding scale of when indemnification obligations trigger. On the one end of the spectrum, causes of action really trigger indemnification obligations very early in the process. There just has to be a right for somebody to sue you in order for indemnification to be triggered and you to seek recovery from the other party. On the very opposite end of the spectrum is actual losses, and this is where I meant to put in the point about final, non-appealable judgments. In other words, if the vendor screws up you get sued as a result. You cannot go after the vendor until there is a final, non-appealable judgment where you actually are out-of-pocket money. It's not until that point until you can actually seek compensation from the vendor. That's not in an ideal term and something you should also be mindful of as well. You should be able to work with your vendor to receive compensation in the form of indemnification much earlier in the process. Carve-outs for gross negligence, bad faith, and willful disregard on the REA's part are fairly common, but just also something to be mindful of. I have the red light flashing at me, so I'm going to go to the last slide on number 17. This is just a hodgepodge of other terms within a contract to be mindful of. I don't have really the luxury of time to go through all of these, and I'm sure some of you are thinking, thank God. But the one thing I would point out just with respect to this slide, dispute resolution. Is it arbitration? Are you going to court? Is it a waterfall provision where you go to mediation, then arbitration? Just be mindful and understanding of where that might be held. Is it in a venue that's convenient to you or not? Choice of law and international considerations. If you're doing vendor contracts overseas, I don't know about you guys, but I have no idea what the law of France is, so I'm not properly equipped to advise on a contract that might be subject to French law. So, Alan, that's where you perhaps can bring in outside counsel. I got a plug-in for you.
There you go.
Seeming boilerplate. Contracts are not exciting documents. I'm stating the obvious. Boilerplate can be important, even though you see a lot of terms within contracts that may be mind-numbingly boring and they all look the same. Words matter, so just spend time to review everything. As I mentioned earlier, don't forget the interplay with securities laws, especially with things such as privacy obligations, Reg SP. Your vendor may not necessarily be entirely versed in the laws and regulations and guidance that we're subject to as RAAs, so just be mindful that there has to be an interplay in that regard. Termination provisions, any penalties for that, how long the contract is, and then lastly, confidentiality. This again goes back to some of the more baseline considerations to make sure that if something does hit the fan or if you guys do go to mediation, things do remain confidential.
And as much as it pains me, I'm going to go back to the previous slide. And one thing that I want to say that you really should put it in all your contracts where there's you're going to be responsible for your liabilities is to make sure you put in reasonable attorney's fees as compared to attorney's fees. So,
Yep.
sorry.
Because you'll never get attorney's
Wow.
fees.
Yeah, as I said, as much as it pains me. But on that note, I think we are over the time just a little bit, but I want to thank my fellow panelists, and thank you very much for the questions.